Hey everyone, welcome to another edition of the Daily Bullet. My name is Paul Lathrop. I'm the Deputy Director of New Media for the Second Amendment Foundation. Joining me today, as he does every Friday, Alex Ooley, although we haven't done a broadcast in a few Fridays. Alex Ooley of the Ooley Law Firm in Indiana. Alex, thanks for being on the show today, man.
Yeah, thanks for having me, Paul. Great to be with you.
So, what we had planned on talking about, we've had this set up, this topic set up for a couple weeks. We wanted to talk about this qualified immunity, and there seems to be a wide range of what people think qualified immunity is, and I just on what I believe qualified immunity is, and that is that. It goes back to my let me give you what I see as qualified immunity, and you can correct me where I'm wrong. Qualified immunity basically says you cannot sue the police department that going back to the times of Magna Carta and noblesse oblige, the king can do no wrong, that somebody, when they're on duty as a police officer, are protected, and what they do as police, they have immunity. They unless it is extremely egregious, when they're performing their duty, they get a free rein to do as they choose. My opinion, that hides bad officers and keeps them in positions they shouldn't be. Am I wrong in that? What is qualified immunity?
I think that's a good setup, Paul, and that captures the concept at a pretty high level. And you're right that this concept of immunity goes back quite a long time. Kings enjoyed what's called absolute immunity rather than qualified immunity. So qualified immunity is different in that obviously it's not an absolute protection. It's a protection most circumstances, but not all circumstances. Whereas absolute immunity is more of an absolute protection that covers just about any type of action. But what we're talking about here, qualified immunity, I think is interesting because it's been a topic over the last year, especially stemming from the George Floyd incident. There was defund the police movement, and there was sort of this separate discussion about qualified immunity, and they're totally separate discussions. Defunding the police is totally different than the qualified immunity discussion, and people on both sides of the political spectrum fall in different places on this. There are many conservatives who support the police but don't support qualified immunity, and so there are lots of viewpoints on this, and it's not necessarily consistent with a political party. Qualified immunity does is it protects police from civil liability if they are sued for violation of the law and what I have to call clearly established law. And I want to point out that this concept of qualified immunity stems from a case back in the 1960s called Pearson versus Ray. And that was a case that came during the height of the civil rights movement. And prior to this, police still had protections for actions that they took in their official duties, but this case created this concept of qualified immunity, which created a higher level of protection than what they had enjoyed prior to this case. And this case, the rationale behind providing qualified immunity was that we don't want to hinder police performing their duties. We don't want to hesitate in enforcing law and carrying out their lawful duties. So that's sort of the rationale behind it. But I want to be clear, important, this is not something created by the legislature. legislature. It's not a creature of statute. The law was created, which goes back to my earlier point about conservatives who sometimes don't qualified immunity, largely because it's a nation of judicial activism, and there's this notion in our country of separation of powers, but want the courts usurping legislative authority. So that's sort of an originalist, socialist standpoint. We don't want courts taking over the authority from them. But nonetheless, we have this doctrine of qualified immunity, and the courts have upheld this doctrine since the 1960s.
Okay, you were breaking up a little bit, but I want to go back and make sure that we understood that qualified immunity is not something that Congress passed and got signed into law. This is something that came out of this court case in the 60s and was decided by judges, and kind of that's how it came to be. It was not through legislation, but through court decisions it came to be, right?
Correct. Yeah, prior to the 1960 case in Pearson, as long as the officer acted in reasonably in faith, they would enjoy protection under the law. But what the qualified immunity doctrine said is that not only do they have that, but they have protection of qualified immunity, which says they cannot be liable unless they violate the Constitution or clearly established law. And that's the key. It's not just if they violate the law, it's if they violate clearly established law. And we're going to talk about what that means here in a minute. But I want to give a little bit of context about where we see lawsuits and where this qualified immunity typically come up. And they're typically in the context of what's called a Section 1983 lawsuit, which is simply a section of federal law 42, United States Code, USC, Section 1983, which is a statute that provides people with a mechanism to sue government officials who violate their constitutional rights or other laws and violate their rights. So typically somebody will bring a lawsuit against a government official through this Section 1983 claim. And a lot of times if it's against law enforcement, the law enforcement defense will be that maybe we violated law, but we're entitled to qualified immunity. It wasn't clearly established law. And what that means is that for a law to be clearly established and to defeat qualified immunity, the plaintiff has to show that a similar case with analogous facts been decided previously that is like the case that such that the officer would have been on notice that what they did was unlawful. So it could be against law, whatever the officer, but if there was not a prior court case said it was against the law such that it was clearly established, then the officer cannot be liable and is entitled to qualified immunity. And this concept was sort of solidified in 1982 with the case of Harlow versus Fitzgerald. And the rationale, and I'll just read straight here from the case, was that the court didn't want to divert official energy from pressing public issues and deterring able citizens from acceptance of public office. So they wanted to create extra protection so that people would be more willing to accept positions such as those positions in law enforcement. So this extra protection was seen as sort of an attraction of to the profession.
Okay. Well, I believe probably attracting the wrong people, but I understand that.
Yeah, and I want to get a little more, maybe with an example about what this clearly established statutory or constitutional right means. So it has to be clearly established law. And there was a case in May of last year, May of 2020. The Supreme Court denied review of the case, and it was this Jessup versus City of Fresno case. And in that case, two businessmen claimed that Fresno police stole more than $225,000. And what's interesting about the case is that the officers in their defense claim that they didn't steal the money. Rather, that there was no similar facts that let them know the money seized with a warrant was wrong. And therefore, because there was no prior case with facts not clearly established. So because there was no similar case prior to this one with similar facts, the officers were afforded the protection of qualified immunity. So there was no question that they violated the law, that they'd done something wrong, but it wasn't clearly established because there was no case with similar facts prior to this one. So you get sort of absurd results, this doctrine of clearly established law under qualified.
Yeah, and we are having real issue. The choppiness of the video is getting worse. Matter of fact, we're starting to get bring this up. Scott says choppy video. Is somebody trying to censor? We're having connection issues, Scott. Alex, that last case you were talking about from last year, was that qualified? What was the business? Was the qualified immunity? Was that the police department or the officers that were trying to seek the qualified immunity? Because I would hope the police officers were. I mean, let's face it. Everybody who's a functioning adult knows theft is wrong. Mm-hmm. And one would hope they were fired and put in jail. And what my mind's eye sees is the businessman says, "Look, you were acting under you were acting as law enforcement. I'm going to sue the police department." Was it the police department that was trying to use qualified immunity to keep from getting sued, or was it still these police officers trying to use qualified immunity to keep out of jail?
So that's a great question, Paul. Qualified immunity only applies to the individual officials, to the individual officers, to the departments, or to the government as a whole. So qualified immunity is a protection for individuals. So the person could still sue the department if there were some legitimate claim against the department, a failure to train, failure to supervise, or some other claim like that. But qualified immunity is just a protection for the individual government official.
Wow. That's holy crap. I'm going to get two comments in here, and these are right up your alley because they are way over my head, but I'm going to get these in. Larry Benson says this is pure BS because it obstructs new case law from moving forward, and he follows it up with, it's called reframing.
Mm-hmm. Yeah, I think he makes a good point here. I mean, if there's no case just like the case that's brought in the past, ever be one like it going forward. It's almost like you're setting up a standard that can never be met, or very rarely. So that's obviously a problem, and as you pointed out earlier, protects bad officers more than anybody else. Because under the standard prior to this qualified immunity doctrine, good officers would still have had the protection of the good faith doctrine. As long as they acted reasonably and in good faith, they would have had protection under the law. Now, I want to be fair and point out one of the counter arguments, and that's that qualified immunity serves to limit frivolous lawsuits. Okay, but here's the other thing. Yeah, I think everybody agrees that it serves to limit frivolous lawsuits. It also serves to limit legitimate lawsuits. okay, which is a big problem.
Mm-hmm.
So we've sort of got the predicament where, yeah, we're limiting lawsuits, but we're also limiting notorious lawsuits. And there are already provisions in the law that help limit and get rid of cases that are frivolous. So I think to the extent that that's a justification, it's one that's overstated.
All right.
One,
Go ahead.
so one thing that I've heard, and I think it's a legitimate, is that maybe it's not a good idea to get rid of qualified immunity writ large, just wholesale get rid of it, because states can still get rid of it in their states. States can limit it. They can pass legislation that says we're not going to apply qualified immunity in our state. And some states have done that. New Mexico, Colorado are a few examples of states that have eliminated qualified immunity. And one of the objections to eliminating qualified immunity is that police officers en masse leave the profession because they no longer enjoy this protection. But that hasn't been the case in New Mexico or Colorado. In fact, there was a decrease in the number of officers who left the force after the law was passed. So I don't think that objection is borne out in reality.
Well, the question I've got, I guess, coming to mind is, Alex, you and I, as regular armed citizens, live with the reasonable man doctrine. In order for us to use our firearms in self-defense legally, we, going back to Masada Ayyub's training, we are judged under the reasonable man doctrine. What would a reasonable person, under the exact same circumstances, knowing what we knew at the time, do? And so I don't know why we couldn't apply that to what would a reasonable officer with the same training this officer had in the exact same circumstances, what would that officer do? Why can't that apply instead of this what we have now?
Mm-hmm. Yeah, I think that's a great point. The rationale behind not wanting that sort of system, the system that you and I are subject to, is that it would result in too many, it would create a great expense for these individual officers. Because remember, these cases, this qualified immunity only protects individual officers, not departments. But the problem with that is that, as we see with budgets around the country, individual officers almost pay for their own. Okay, even if that are against the individual officers, they're typically paid by their departments or by their local government. So I think that also sets up a false narrative in that it would harm these officers because they'd have to pay for their own defense without qualifying. But as we've seen, departments will pay for their officers' defense. In fact, I think well over 99% of all defense expenses nationwide are paid by departments, not by individual officers. So I don't think that's a great counter argument to having a system that's more like the good faith defense that they had prior to qualified immunity.
All right.
And I want to point. Go ahead. So I want to point out too that there have been some efforts to limit qualified immunity or to eliminate it. In addition to the states that I mentioned earlier, Colorado and New Mexico, there was some legislation at the federal level to eliminate qualified immunity. Justin Amash proposed the legislation, but it never really got any traction. And so there's not really movement to eliminate qualified immunity through the legislature. But because it is a court-made doctrine, okay, the courts can always revisit this doctrine. And in fact, some justices have voiced concern about qualified immunity and have indicated that they believe the doctrine should be revisited. Justice Clarence Thomas has expressed some concern about it, said the court should revisit the doctrine. Justice Scalia, his passing, voiced the same concerns and also said that it needed to be revisited. So these are conservative justices, some of the most conservative justices on the court in the last few decades, and they believe that the doctrine is flawed, that it's a court-made doctrine created by judicial activism, and that it needs to be revisited.
All right, a couple more comments, and we're getting some very good ones coming in. Larry Benson again commented, this is a double standard because what a reasonable belief of an officer is discounted as a reasonable belief by a citizen. What do you think there, Alex?
Well, I think sometimes there is a different standard applied to police rather than the general public. But if police were subject to the same reasonableness test that the rest of us were, I think juries are still very sympathetic to police and would, provide protect police where their acts were reasonable in light of reasonable officers would have done in their situation. And I think Massad Ayub uses this quote. He says, "You can't be expected to have detached reflection at the hand of an upheld knife." Okay, and the same standard would apply to police officers in a moment of intense scrutiny where you have to act in seconds. They can't be expected to have this detached reflection, and I think that's something that a jury would consider for police, just like they would for you or me. But with that said, I think juries would often, depending on the locality, of course, be sympathetic to police action. Because people want an effective police force, and as long as the officers act reasonably, they should be protected.
Next question coming in. Charlie Chambers, as a layman, if asked what qualified immunity is, what is a proper response, elevator speech, as a reasoned response?
So, qualified immunity is a protection for government officials who have not violated clearly established law. And clearly established law is law that has been acknowledged and made clear by prior court cases, by precedent. So that's not exactly a layman's explanation, but it's pretty close.
So when we're coming up on the time we have, we only got about 5 minutes left, but where we sit with qualified immunity, New Mexico and Colorado have at least limited it, if not done away with it. Am I correct there?
That's correct.
Where do we sit with, so in 48 other states, it's not law, it's court, it's the rules we live under, but it's going to take either revisiting by the courts or legislation to change it, right?
Correct. And one thing I want to point out too is that, I believe that police form a necessary function in society, and qualified immunity is problematic, but I think there are other policing that create situations where we get these absurd results with qualified immunity. For instance, I think that the problems stem from the fact that we have far too many laws, and police are tasked with enforcing those laws. And the more laws that we have, the more laws that police to enforce, and that creates more potential for problematic interaction with the general public. So I think that there are other solutions also besides just the qualified immunity. I think that we need to talk about other, like over criminalization, because I think that brings peace into contact with the generation when they really shouldn't be in contact with them.
Another issue, and this is going way off into left field here, but one other issue, and one that I have a big problem with, is treating police agencies, and this goes all the way down from the local on up to the state police, as sources of income via fines. The government agencies of all levels will get income from fines and will sometimes exert pressure on police departments to keep that income coming, and that always creates issues, and I think that is again where we get a lot of bad officers, is from departments like that.
Mm-hmm. Yeah, there's this whole other issue of civil asset forfeiture, right, where police officers are incentivized, I think, with perverse incentives to confiscate people's property under the guise of enforcing the law. In fact, it's mostly a fundraising opportunity for lots of departments. And I think that creates lots of interactions with the police.
Yep.
So this concept of civil asset forfeiture, I think, is a pretty flawed dogma.
Absolutely. Well, we are coming up on the bottom of the hour. That's the time we have today, Alex. And again, the internet gremlins are creeping up. It seems that your internet is starting to freeze up on us again. So I think we're going to go ahead and set this one aside here. Great discussion today, and we've got great comments in from viewers. Thank you so much, everybody, for the comments you brought in. Alex, thanks for joining us today, man.
Well, thanks for having me, Paul.
All right. I want to encourage everybody again, come join us again next week, Monday through Friday, 5 p.m. Central Time. Every day we'll be talking about the news of the day, and Alex will be back next week. We'll be talking about another legal aspect of Second Amendment law. Thanks again for watching, everybody.